Welcome, I am the loud little ducky. Today, big news and hopefully final news in the Owens V Echard case. This should mean it is closed. Hopefully, there's nothing further on this case, even though there is going to be further videos about Owens in the future with other men that she has done things to. But Owens loses her appeal. Ginger said that, oh, we're going to win it. We're going to win it. He's going to lose. Y'all don't know anything. Newsflash. We apparently know more than you, Mr. 20 years of experience. But let's dive into what the appeal has to say and provide commentary on it. In the Arizona Court of Appeals, Division 2, Laura Owens, petitioner/appellant, v. Clayton Echard, respondent or appellee. And this was filed on March 28th, 2025. This decision does not create legal precedent. Oh, poor Jingy. No legal precedent for you. And may not be cited except as authorized by applicable rules, not for publication. So sometimes you'll hear in court cases where this is like, oh, this is a published case, and they will cite to those things. This is not going to be a published case. Like there's nothing spectacular about this appeal. Except for like Clayton, but as far as law goes, there's nothing exciting or new in this. It just proves Gingras wrong. Appeal from the Superior Court in Maricopa County for the judge Julie Mata, and it is affirmed. Mata's ruling is affirmed, which means they are holding up her ruling. What she ruled back on June 18th is what stands. And it was sent to the lawyers. Owens v. Echard, decision of the court. Memorandum decision. Judge Vasquez authored the decision of the court in which presiding Judge Eckerstorm and Judge Schuyler concurred. So, 3 judges. Vasquez, judge. In this paternity action, Laura Owens appeals the trial court's award of attorney's fees and costs in favor of Clayton Echard. She argues that Echard's failure to comply with the safe harbor requirements of Rule 26 of Arizona Rules of Family Law Procedure preclude sua sponte sanctions under any authority, and the amount of fees and awards was unreasonable. She also argues to the court that court committed structural error by conducting its own post-trial investigation into the facts of the case. For the following reasons, we affirm. Factual and procedural background. We view the facts in light of most favorable to sustaining the trial court's findings and orders. So the way they view it is most favorable to the way the judge ruled. And they cite Hefner v. Hefner, which is an appellate case from 2019 in Arizona. So in May 2023, Owens and Echard had an intimate encounter. Shortly thereafter, Owen learned she was pregnant. In August 2023, she filed a paternity petition alleging Echard was the father. Echard denied the paternity. Well, that was the quickest TDRL of that time period. In December 2023, the case was placed on the administrative dismissal calendar for lack of prosecution. Echard moved to extend the dismissal date, arguing that he was entitled to an adjudication finding of non-paternity. He also requested an evidentiary hearing on paternity issues, attorney's fees, and Rule 26 sanctions. In response, Owens informed the trial court she was no longer pregnant, and thus there was nothing left to adjudicate, and the case should be dismissed. She simultaneously moved to dismiss the case with prejudice. Echard opposed. Echard then separately moved for Rule 26 sanctions, arguing Owens' petition was filed for an improper purpose. Her motion to dismiss was unsupported by existing law, and her factual contentions were not supported by evidence and did not become supported by evidence after the investigation and discovery. Owens responded that Echard had not complied with Rule 26 requirements because he did not provide her with written notice of specific conduct alleged to have violated Rule 26, and that she was therefore not afforded time to cure any alleged deficiencies. Echard eventually moved to withdraw his Rule 26 motion, arguing that there was no reason to participate in the pointless litigation over this issue. Notwithstanding his disagreement with Owens' legal positions on Rule 26, because Rule 26 was not substantive pleading based for his claims for attorney's fees and sanctions. The court extended the dismissal deadline, denied Owens' motion to dismiss, and set an evidentiary hearing on the issue of sanctions and attorney's fees. After the evidentiary hearing in June 2024, the trial court granted Echard's request for attorney's fees and cost. In July, Owens filed a notice of change of judge for cause under Rule 6.1 Arizona Rules of Family Law Procedure, arguing the judge was biased and had engaged in conduct that violated her right to due process. The presiding judge denied her motion, concluding Owens had failed to prove by a preponderance of the evidence that the judge was biased or prejudiced. Also, in July, Owens moved for relief from the judgment or alternatively to alter or amend the judgment, which the court ultimately denied. In August, the court awarded Echard fees and costs in the amount of $149,219.76. The appeal followed. We have jurisdiction under ARS 12.120.21 and 12.2101A1. All right. Now we go into discussion. So that was just the backstory. So now we go into discussion. Attorney's fees. Owens argues that because Echard did not comply with Rule 26 safe harbor requirement, she was shielded from any punishment arising from her alleged violation of Rule 26. And so in the footnote here, it says the trial court's August 2024 judgment was not certified as a final under the applicable rules, and the June 2024 ruling was improperly certified as appealable under Rule 78B, Arizona Rules of Family Law Procedure. We therefore suspend the appeal and revested the jurisdiction with the trial court to allow it to enter its final appealable order. After the court amended the August 2024 judgment to include the requisite finality language under Rule 78C of RFLIP, we vacated and stay and reinvested the jurisdiction in this court. So that was what we had just recently went over. Some legal language needed to be happened, and then the appeal started again. And then talks about Rule 26B provides that by signing a court filing, a party is, among other things, certifying that it is not being filed for an improper purpose. The claims are supported by the existing law and are non-frivolous, and the factual contentions have evidentiary support. If a party violates the rule, the trial court may impose sanctions, including reasonable attorney fees, Arizona Rules of Family Law Procedure 26C. However, before seeking sanctions under the rule, the moving party must attempt to resolve the matter by consultation, Arizona Rules of Family Law Procedure 26C2. Okay. So, it says, as preliminary matters, we wrote that a significant portion of Owens' appellate argument relies on her incorrect assertion. Gingriss's incorrect assertion. Yes. Incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly awarded fees and costs under 25-324 and 25-415, which we have been saying from the beginning. She clearly states this is what rules I am awarding these fees under, and nowhere did she put that she was awarding them under 26. It was in black and white for Gingras to look at. We thus decline to consider whether an award under Rule 26 would have been proper. See footnote 3. In its ruling, the trial court ruminated about whether it could sua sponte award sanctions under Rule 26 after a party moves and then withdraws a motion for Rule 26 sanctions. Presumably, it did so because this question was heavily litigated by the parties below. Ultimately, however, the court did not award Rule 26 sanctions. Yeah, she didn't. She said, I thought about it, but I decided I could give you sanctions under these and not even do Rule 26 so that we avoid the whole Rule 26 argument altogether. But Gingras couldn't get away from Rule 26. He kept wanting to bring it back because he thought that as soon as he came in with his Rule 26 argument, he thought automatically Owens wins her case. And then Rule 26 got revoked. Gingras' arguments were turned down over and over and over again, and he has been told he's wrong. This is not how the law works. But he doesn't care. And then it says, see Freeport, McMoran Corp. v. Langley Eden Farms, an Arizona appellate court case 2011. Appellate courts do not decide unnecessary issues or issues advisory opinions. So because this was not an actual issue, because there was nothing ruled on in the final judgment under Rule 26, they're not even going to address this because it wasn't a thing. Quit trying to make fetch happen with Rule 26, Gingras. It's not going to happen. We review the trial court's decision to award fees and sanctions under 25-324 and 25-415 for an abuse of discretion. Myrick v. Maloney, Arizona Appellate 2014. Hayes v. Gamma, Arizona 2023, discovery sanctions, but we review a court's interpretation and application of statutes de novo. Clark v. Clark, Arizona Appellate 2016, and Rippey v. Rippey, Arizona Appellate Court 2004. Owens argues that because the hearing was set in response to Echard's Rule 26 motion, and because he did not file any other motions for fees and sanctions, of course the court sanctioned her under Rule 26. Relying on Rule 35A1, Arizona Rules of Family Law Procedure, Owen contends a fee or a sanction request must be made by a separate motion. While this is true for a Rule 26 sanction, according to the Arizona Rules of Family Law Procedure 26C3A, the same is not true for attorney fees requested under 25-324. Arizona Rules of Family Law Procedure 78E1. See Lundy v. Lundy, an Arizona appellate case from 2017, or sanctions for litigation misconduct under 25-415. Hayes, Arizona, 1999, I guess. Court can impose discovery sanctions under its inherent contempt power. She had the right to give sanctions for litigation misconduct, which Owens committed tons of, and because Echard sought attorney's fees. And I can't remember if Gingras did a separate motion for request of attorney's fees, because if he didn't, how did he think Owens was going to get attorney's fees and costs if he didn't do a separate motion? If he thinks this is how it goes. But he thinks Rule 26 supersedes everything. The appellate court says, no, it doesn't. There are other sanctions you can do things under. It's not the end-all be-all. Nevertheless, Echard properly requested attorney's fees and costs under those authorities throughout the litigation. Where Jingers is like, no, he never requested this stuff. Yes, he did. We've gone over that. Many other people have gone over it. Clayton asked for that in one of his first filings ever when he was, when he was being his own attorney, pro se. He asked for him then, before he even had a lawyer. For example, he requested attorney's fees and costs under 25-324 based on Owens' unreasonableness in his motion to extend the dismissal date on the inactive calendar and schedule an evidentiary hearing, which was filed. It was filed before Owens moved to dismiss the case. Echard made the same request under 25-324 in his reply as well, as in an amended response to the paternity petition. Moreover, in Echard's motion to withdraw his Rule 26 sanctions motion, he argued that he was entitled to attorney's fees and costs under 25-324, 25-415, and 25-809G. That his claims for fees and sanctions exist independently of Rule 26. See footnote 4. Echard repeated this argument in his response to Owens' combined motion for judgment on the pleadings and his renewed motion to dismiss. The trial court found Owens' motion to be moot and declined to take further action. However, there was a delay in the parties' receipt of the court's ruling, and the court found this motion was filed with the belief the court had not accepted Echard's motion to withdraw. Which we remember that when there was a delay for the rulings to come out, for some reason they didn't get filed properly, and Jingers was filing things and asking for a ruling and all that, but everything was accepted, and Clayton still asked for proper sanctions under other authorities, not including Rule 26, because Rule 26 was done and gone. They withdrew it. Continues on, paragraph 10, Owens argues that the trial court lacked the authority to oppose attorney's fees and sanctions independently from Rule 26 because Echard filed subsequently, I don't know why I can't say that word today, withdrew the Rule 26 motion. She maintains that Rule 26 must control and must provide the exclusive remedy for conduct that would fall under Rule 26 violation. In support of this argument, she is more specific rule controls. In Remarriage of Thorne, Arizona, Appellate Case 2014, but the statutes under which the court granted attorney's fees did not govern the same subject matter as Rule 26. Section 25-324 governs attorney's fees, not sanctions. Yeah, she awarded attorney's fees. She didn't award sanctions. And the sanctions for cost and attorney's fees that the court ordered under 25-415 were based on Owens knowingly presenting a false claim and knowingly violating a court order compelling disclosure or discovery. Yeah, like your Los Angeles bullshit. You were supposed to hand that over and you didn't. Right there, you can get sanctions because you defied the court order. Compare 25-415A3 with Arizona Rules of Family Law Procedure 26. We decline to hastily find a clash between a statute and court rule Duff v. Lee, Arizona 2020 case, especially when the statute and rule govern different subjects. Yeah, they don't even have to do with the same thing. One is attorney's fees, one has to deal with sanctions. And there were no sanctions given out in this case, just an attorney fees award. Jingers doesn't get it. Owens next argues that the attorney's fees and costs awarded under 25-324 and 25-415 were improper because they were neither necessary nor reasonable. She asserts that Echard's fees were literally $0 prior to November 2023, and his counsel had simply picked up the phone in mid-December and asked her about her intentions, she would have informed him that she was no longer pregnant, and there was nothing further to litigate. She similarly argues that Echard's decision to file Rule 26 motion was precipitating factor in occurring fees. She contends that if Echard had done nothing, the case would have been administratively dismissed without a single dollar of fees incurred by either side. Therefore, she maintains that even if her petition were unreasonable, it was not the filing itself that caused the fees to be incurred, but rather Echard's choice to pursue sanctions. But that administrative dismissal would have been without prejudice. Correct. So it would not have precluded Owens from initiating a further paternity action, nor would that dismissal have been equivalent to the order Echard sought and ultimately obtained, that he was not the father in connection with the alleged pregnancy. At any rate, none of these scenarios posted by Owens have any bearing on the propriety of the fees awarded in this case, as that determination must be based not on conjecture, but on what actually occurred. So the appellate court is saying this is not being based on whatever you think it says. It's being based on what actually happened. So whatever you have going on in your little Delulu brain does not go with reality. Let's see what else they say. At the time of Echard's request for evidentiary hearing on the paternity issue, attorney fees, and Rule 26 sanctions, Owens had not informed him she was going to move to dismiss the case. And in her response to Echard's request filed simultaneously with her motion to dismiss, she acknowledged that the only remaining issue was Echard's request for attorney's fees. Echard objected to Owens' motion to dismiss, arguing her avowal that she was no longer pregnant was insufficient to grant a dismissal. He also requested an adjudication that she was never pregnant, or at least that she was never pregnant by him, and an evidentiary hearing on his attorney's fees requested. The trial court ultimately granted Echard's motion to extend the dismissal deadline, dating the issue of sanctions and attorney's fees remaining. Owens does not challenge this ruling on appeal, and the fact that the parties incurred attorney's fees because they heavily litigated the issues was within the court's discretion to consider and not something this court will reweigh. Like, we're not going back over that stuff. We're looking at law. And we've gone over that as well. If you're like, okay, you're not pregnant. But guess what? We still have to talk about the paternity, and we still have to talk about the attorney's fees. So there were like 3 things that were up in this case. We got rid of one part of it. We still had 2 other subjects remaining. But she doesn't see that. She never will. Paragraph 13, here the trial court found Owens had acted unreasonably in litigation by filing the case without basis or merit. See 25-324, court may award attorney's fees after considering, in part, the reasonableness of positions each party has taken throughout the proceedings. See Maggie v. Maggie, Arizona Appellate 2020 or 2004. And appellant need not show both financial disparity and unreasonable opponent in order to qualify for consideration for an award. The court also found disingenuous at best, but certainly misleading to the court, that Owens had testified the purpose of her motion seeking mediation was to inform Echard the pregnancy was not viable. It further found she had failed to comply with the disclosure requirements, which caused Echard to incur substantial legal fees attempting to locate records that may or may not have existed. The court also concluded that 25324B applied because Owens had provided false testimony as to the viability of the pregnancy and had sent Echard a letter prior to her deposition that indicated her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. So in that, I just found a blog post that I'm going to go over in a future video that's going to come out later this week, where she talks about this whole money and real estate thing. It's very interesting, but we're going to go over that. And so be on the lookout for that video. But yeah, she extorted him here. They go on to say, on appeal, Owens does not meaningfully challenge these findings, but instead argues 25324 does not apply in paternity actions. Section 25324A permits a court to order a party to pay a reasonable amount to the other party for the court or for the cost and expenses of maintaining and defending any proceeding under Chapter 3 or Chapter 4, Article 1 of this title. Chapter 3 governs dissolution of marriage and relevant here. Chapter 4, Article 1 governs legal decision-making in parenting time. Owens argues the paternity actions are by definition excluded. A family court's authority to conduct legal decision-making in parenting time proceedings is provided by ARS 25402. Under that statute, a parent is required to request such a determination in any proceeding for marital dissolution, legal separation, annulment, paternity, or modification of an earlier decree or judgment. 25402B1, C. Tanner v. Marwill, Arizona Appellate 2020. Here, Owens petitions the trial court for orders concerning paternity, legal decision-making, parenting time, and child support. While the court ultimately did not issue legal decision-making and parenting time orders, Echard defended any proceeding under Chapter 4, Article 1 of this title by virtue of Owens' petition, as was reflected in his amended response, 25324. Yeah, it cost him money to fight those parts, even though she's like, no, it did cost him nothing to do anything. Even assuming the trial court's fees award was improper under 25324 because of this case procedural posture, the court's findings would have supported a fee award under 25809G. See Forrest v. Rodriguez, Arizona, Appellate Court 2006. We may affirm trial court if legally correct for any reason. Echard cited 25809 in seeking attorney's fees, so the issue was also properly before the court. So even if we took 25324 off the table, or 25402B, he also asked under 25809G, and that one was still applicable and was before the court to decide on that part. The language in 25809G largely mirrors that in 25324A and permits a court to order a party to pay reasonable amounts to the other party for the costs and expenses of maintaining or defending any paternity proceeding. We reject Owens' suggestion that this paternity action somehow transformed into some other type of proceeding because the parties only incurred fees after it was scheduled for administrative dismissal without prejudice. The court did not err in awarding attorney's fees. Yeah, it wasn't an error to give Echard his fees. It was well within the court's discretion to do so, and they did it. And I'm sure they're probably thinking, and good for her, she should have. But she didn't err in doing this. The trial court also properly awarded fees and costs as a sanction under 25-415. The court found that the fees under the statute were appropriate because Owens had knowingly violated a court order compelling disclosure or discovery. Owens argues she fully complied with the court's disclosure order, as was demonstrated by the fact Echard never brought any motion seeking sanctions under ARS 25-415. She argues because no motion has been filed. She did not argue, or she did not have the opportunity to prove she fully complied with the court order. Although 25-415 does not require the filing of a separate motion as previously noted, Echard requested relief under this statute. Ma'am, you're not going to be able to prove that you complied with the court's order because you got on the stand the day of the evidentiary hearing and stated you went to Los Angeles and had not provided that discovery, which means you did not comply with the court order. You had plenty of time to do so. So get out of here with that shit. Stop with your nonsense. It's not going to fly anymore. Section 25-415A3 states that the court shall sanction a litigant for cost and reasonable attorney's fees incurred by an adverse party if the court finds the litigant violated a court order compelling disclosure or discovery. See footnote 5. Section 25-415A3 provides two exceptions if the court finds that the failure to obey the order was substantially justified or the circumstances make an award of expenses unjust. It is not required to impose sanctions. The trial court made no such findings here. Yeah, the court, Mata didn't impose sanctions at all. She could have. She should have. But she just awarded attorney's fees. That's the only thing that she was punished with. She could have had way more happen to her. And Judge Mata did not overstep in doing so because she could have done it. But Laura not turning over Los Angeles stuff was not justified because she could have turned it over. She had every way to get her medical info and hand it over. There was nothing stopping her from being able to get that and turn it over, other than she didn't want to because it's a lie. Okay, going back up. Here the court made such a finding, thus it was required to sanction Owens for the cost and reasonable attorney's fees Echard had incurred. Owens does not meaningfully challenge that finding. Again, the court did not err in awarding Echard his cost and reasonable attorney's fees. Once again, they didn't err. No errors here. So that's twice they've said that. On appeal, Owens also claims the amount of the fee award was unreasonable. The substance of her argument is that below she had noted the amount of fees was patently unreasonable in light of the controlling standard of ethical rule 1.5. But because she fails to identify with any particularity that evidence supports her argument, we conclude the court did not abuse its discretion in fixing the amount of the attorney's fees it awarded. Echard. A minor contracting incorporated vs. Toho Toloni something, Arizona, 2013. Yeah, she didn't point out where the amount was unreasonable based on what standard of the ethical rule, nor did she write things supporting her standing on that. She just said it did. And if they were trying to save that for oral arguments, they messed up. Put it in your papers first. Put it on paper. Denial of a motion for relief from judgment. Owens argues that the trial court erred by denying her motion for relief from judgment or alternatively to alter or amend the judgment. We review the denial of such motions for an abuse of discretion. Pullen v. Pullen, Arizona, 2009. Motion to alter or amend judgment. Can't even pronounce that case. Motion for relief from judgment. Because Owens does not argue how the court erred in denying her motion, but instead asserts that the only available remedy is automatic reversal because the misconduct is per se structural error. Yeah, they're not saying she erred because of this and this and this and this. They just said, we don't need to say why she erred. You just need to reverse it because that's what you have to do. Well, if they don't see it that way, maybe you could give them some reasoning. Once again, had you not wasted half of your appeal, more than half of your appeal on Rule 26, maybe you would have had the pages to put in here those arguments on these things, on these ethical rules. But you didn't because you were trying to have oral arguments instead of just putting it in your papers. Just put it all on the paper. And then, if they think you have something based on your papers, they will either grant it or deny it still on the papers, or they're like, you know what? They kind of have a point here. I want to hear more about that, so let's bring them in. But you didn't do that. You didn't even give the appellate courts reasons for things. And if you don't back up your mumbo jumbo here, what are they going to do? You didn't give them a reason. You just said, oh, you need to reverse it. Mata bad. Well, that's not enough. And it talks about, oh, they did structural error, the most obvious kind. We do not address the court's denial of her motion. They cited a case, undeveloped argument waived on appeal. Yeah, you did not develop this argument. You could have, you decided not to. Maybe because you didn't have any more pages left that you could put in. But if you would have wiped out Rule 26, you would have had plenty of room and pages to argue these things. Judicial bias. Owens argues the trial court improperly performed an independent and undisclosed investigation into the facts of this case, and from this investigation made post-trial findings not based on the evidence admitted at trial. In the findings of facts section of its ruling, the court stated that Echard's expert had testified that Planned Parenthood is not open on Sundays when Owens testified she sought care July 2nd, 2023, a Sunday. The parties agree the expert did not testify that Planned Parenthood is closed on Sundays, and that the court's finding was therefore erroneous. Instead, they dispute that standard of review should apply. Owens argues this amounted to structural error requiring automatic reversal, because Mata bad. Because it proves the trial judge was biased as shown by the judge's decision to engage in unlawful conduct which violated her right to due process. Conversely, Echard argues that the controlling standard for alleged mistakes in family law proceeding is harmless error. Structural error is generally applied in criminal cases and is error that affects the framework within which the trial proceeds rather than simply an error in the trial process itself. State v. Henderson, Arizona 2005, the Supreme Court has defined relatively few instances which we would regard error as structural. But one of those instances is a biased trial judge, State v. Ring, Arizona 2003. We nevertheless decline to apply a structural error analysis given the record before us. So, with everything you told them and everything you submitted, it's not going to be a structural error because that finding was not the structure of this case. Planned Parenthood being closed was not the framework of this. Laura being pregnant with Clayton Echard's child and Clayton saying, no, she's not, she lied, is the framework, is the structure. It's how you can remember structural error. And just with that fact that was inside the house of the case, so it's inside the structure, but it wasn't a part of the structure. So therefore it's harmless error. Because things that go on inside the house a lot of times doesn't exactly affect the framing of your house. Your bricks are still going to be standing, your beams are still going to be up, you're still going to have a ceiling and floor. Now, sometimes there are things that can destroy the structure, like a biased judge that would destroy some of maybe the beams of the ceiling or the flooring of your house, your structure. But a place being closed on Sunday had nothing to do with the structural part of this trial, this case. It says which trial proceeds rather than simply an error in the trial process itself, which I stated. Here, Owens moved for a change of judge for cause under Rule 6.1 Arizona Rules of Family Law Procedure on the basis of bias and prejudice within the meaning of ARS 12409B5. The presiding judge denied her motion while acknowledging that the trial judge finding about Planned Parenthood's business hours was clearly erroneous. The presiding judge concluded that Owens had failed to show by a preponderance of the evidence that this finding reflected bias or prejudice against her. Owen contends that we need not to separately decide whether the presiding judge erred when she denied Owens' notice of change for judge for cause, because she requested relief is subsumed with the structural error arguments that we must review de novo. But as we explained below, the record does not show that the trial judge was biased. Thus, even assuming without deciding the structural error applies in family cases, it did not occur. The presiding judge did not abuse her discretion in denying Owens' motion for change of judge for cause. See Stagecoach Trails v. City of Benson, Arizona 2013. Re-review for abuse of discretion, the denial of a motion for change of judge based on a claim of judicial bias. Yeah, because you can't say that she looked up these facts. She looked up these facts of Planned Parenthood if she did. We're going to say for this argument, let's say what they're saying is true, that she looked up these facts and did an independent investigation. How can you prove that she was looking up and doing an independent investigation into the facts because she was against Owens? What if she was actually looking up those facts because she supported Owens and was trying to be like, okay, she was right here. Like, you cannot prove that the independent investigation was because she was trying to prove Owens wrong or whether she was trying to prove Owens right. So therefore, because you cannot prove which one it is, how can you say she's biased? Because it could have been a bias against Echard if she was trying to prove Owens right. Based on your logic, it doesn't make sense. Owen argues the trial court's erroneous findings of fact demonstrate it was biased and therefore committed structural error. Her argument is based on conjecture. She does not provide any evidence showing actual bias. Her claim of bias is based on her assertion that the court intentionally tried to conceal its misconduct in performing its own post-trial investigation into the facts by falsely attributing the testimony to Echard's expert. Owen claimed that the only plausible conclusion, given the online supporters of Echard had ferociously posted about this issue online hours after the trial ended. These unsupported and speculative allegations fail to meet the burden to prove bias by preponderance of the evidence. See State v. Ellison, Arizona 2006. So it is unsupported, which means you do not have any evidence and you are speculating. And with no evidence and speculation, you cannot meet your burden of proving it by a preponderance of the evidence. Not a preponderance, but a preponderance. Owens further contends that any independent factual investigation a trial judge is unlawful and shows bias, but for structural error review to apply, the type of judicial bias that must be shown is that which implicates a party's due process rights, such as bias based on direct personal, substantial, pecuniary interests. State v. Grandos Appellate, Arizona 2014, quoting another case, none of those grounds apply here. We therefore review for abuse of discretion. While a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias apart from any structural error claim, see State v. Emanuel, Arizona Appellate 1989, the critical inquiry that would require reversal is whether the conduct demonstrated an extrajudicial source of bias or deep-seated favoritism. Stagecoach Trails, they've already cited that case. Owens correctly notes the court misstated trial testimony, but she is incorrect in asserting that because harmless error analysis does not apply, she does not need to make a separate showing of resulting prejudice. Prejudice will not be presumed, but must be evidenced from the record. Yeah, we can't just presume there is prejudice. You need to show us where the prejudice is. The only reason you find it biased and prejudicial is because it did not go in your favor. Had she done this independent investigation and found out that it was open on Sunday, you would not be claiming this stuff. You just don't like it because it didn't work out in your favor. And this says, see Arizona Laws Family Procedure 86, unless justice requires otherwise, an error by the court or a party is not grounds for disturbing a judgment or order. Maybe if you would have read some more of Arizona Rules of Family Law Procedure, Gingras, you would know more. Read up on your family law. Therefore, even if a court conducted an independent research under a prejudice analysis, we would still We would still have to determine whether Planned Parenthood's business hours were vitally important to the court's ultimate conclusions, as Owens claims. Yeah. And to me, those don't matter because without those, before we even knew the hours of Planned Parenthood, you have so much evidence to prove that you lied about this pregnancy without that. Like if we just take that fact completely out, it does not change this case. It just doesn't. Now, if that was the only thing that made her decide that you were a liar and you didn't have perjury on the stand, you didn't have doctored medical records and sonograms in the file, maybe that would have been a factor more important. But because you had all of that and you failed to turn over this evidence, whether Planned Parenthood was open or not has nothing to do with why you lost this case. And to think otherwise is just stupid. They go on to say, however, Owens does not argue prejudice. Consequently, the presiding judge did not err, once again, in denying Owens' motion for change of judge for cause. The record does not show judicial bias, and Owens does not challenge any of the presiding judge rulings under the appropriate standards for appellate review. So you wasted your whole appellate argument you didn't even argue appropriate standards. You argued about a Rule 26 motion that was moot and was non-existing when this case had its final judgment. Then you went on to just state things as fact instead of arguing based on law and tying it and tethering it back to it and proving your points and showing. You just said, oh, because it is. Because this is what has to happen. But you don't give any support of why. You don't back any of your things up, and you're not applying the right standards, and you're not using them appropriately. Attorney's fees on appeal. Owens and Echard requested their attorney's fees and costs on appeal under 25809G. Echard additionally requests fees and costs under 25324. Both under statutes, the court may award attorney's fees and costs after considering the financial resources of both parties and the reasonableness of positions each party has taken throughout the proceeding, 25324A, 25809G. While the record does not support a disparity in parties' financial resources, Owens' position on appeal is unreasonable. Let me state that again and let's highlight it. Owens' position on appeal is unreasonable. Like, you shouldn't have even filed for an appeal. It was so dumb. You made no reasonable arguments under appropriate standards. You argued mute points. You have assertions and speculation and conjecture in here, which is not what the courts need. So, McGee, Arizona, her Rule 26 argument is not grounded in law or fact. Yep. We just make up laws over there. Mr. Jinger's 20 years of experience just makes up shit. Likewise, her assertion that the trial judge was biased and committed structural error does not meaningfully address the trial court's ruling below and also ignores the applicable jurisprudence. We therefore award Echard his reasonable award attorney's fees and costs on appeal upon his compliance with Rule 21, Arizona Rules of Civil Procedure, C, 25809G, fees 25341, costs. So this was so unreasonable and so bad and ignorant that they made up law, they made up facts, they said nothing meaningful. So therefore, you're also now going to pay for Echard's appellate fees. So you owe more money than that $150,000 on top of it. Whereas all you would have had to do is take the defeat because you lied, and you know you lied. Because you have knowingly done this bad behavior. You knowingly brought this case, knowing you were not pregnant. And instead of just accepting that you lost, you threw your temper tantrum, and you could have just paid your $150,000 and let it be, taken your loss and gone on about your business. But no, still knowing you lied, you decided to go for an appeal. That your lawyer was sitting there and telling you, oh, it's so strong, y'all just don't know. Like, I am the best of the greatest. Your lawyer took you for a ride, Owens. He took you for a ride. He made you look even dumber. But you listened. You listened to this idiot. And because of that, you now owe more money than you originally did back in the summer. And if you continue going with this, the money is just going to keep stacking up. You weren't happy with $150,000? Well, now, congratulations. You owe more. Were you happy? Would you be happy with just the 150 now? It wouldn't be so bad if you didn't knowingly do these things. And then you went at the appellate court with a bunch of bullshit that doesn't matter. Ending this out on what they said, disposition. For the foregoing reasons, we affirm the trial court's judgment. Meaning, what Judge Mata said in her final judgments about the attorney's fees and costs, and that Owens is a liar, a knowing liar, stands. They have backed Mata in this ruling. I don't think you should go any further with it. I don't think you should have Gingras as a lawyer anymore. He has not done you any favors. He's made you look like an even bigger buffoon. But you're not going to listen to us just because we say that you've lied. Just admit defeat. Closing out with our quote of the day, punishment is not for revenge, but to lessen crime and reform the criminal. Owens, you are not being punished out of revenge. You are being revengeful. Clayton was not. But hopefully this punishment lessens you being able to do this to another man ever again. And hopefully you learn your lesson and you stop doing this to people. You realize the error of your ways, that this is not how you get a man. This is not how you're going to find love. This is not way to do it. So we want to lessen your criminal acts, and we want you to be reformed. Whether that's finding Jesus or whatever. You didn't get punished for people hating you. You haven't even been punished. You just have to pay some attorney's fees right now. But maybe if you showed some remorse or you admitted to your wrongdoings and apologized, maybe even Rachel Mitchell would back off. I don't know what Rachel Mitchell is doing there. I don't know if she's going to do anything or if she was waiting to see if this ruling was still going to stand because they have a stronger criminal case with this ruling standing than if it was to be reversed. But there are lots of ways to do better from here. And this should be a huge lesson to you. But we know it's not because of the bullshit you pulled in your ex parte renewing of a restraining order, protective order against Greg Gillespie, which that will be covered soon here as well. We have a couple more videos coming out in regards to this Owens saga, some blog posts by Owens and Gingras, and then we will also do a quick video on Schnitzel's Ninja's video of the hearing, and I will give you my thoughts on that as well. So stay tuned, turn those notification bells on, subscribe, hit that like button, and I will see you next time. Bye.